and advocate late Vishnu Pant Adwant. As the sacred flame illuminates the space around us, may it also kindle the light of wisdom within, dispelling the darkness of ignorance and ushering in truth, clarity, and grace. One of the most distinguished and transformative jurists of contemporary India, Honorable Dr. Dhananjay Chandrachud. I invite Advocate Harish Adwant to formally introduce our distinguished guest.
Good evening, everyone. I am alive to the fact that while I may not be best suited to introduce such a towering personality in his lordship, and that it would tantamount to showing torch to the sun, I stand before you, discharging the obligation cast upon me. It is my absolute honor and privilege to introduce one of the most distinguished and transformative figures of Indian judiciary and the chief guest for today's lecture, Honorable Chief Justice Dr. Dhananjay Chandrachud, the former Chief Justice of India. Born on 11th November 1959 in a family steeped in legal tradition, to late Sri Yashwant Chandrachud, the longest serving Chief Justice of India, and Srimati Prabha Chandrachud, a classical musician who worked with the All India Radio. Justice Chandrachud attended the Cathedral and John Connon School in Mumbai and St. Columba School in Delhi in his formative years. After completing his graduation in economics and mathematics from St. Stephen's College, Delhi, he obtained his bachelor's degree in law from the University of Delhi, followed by Master of Laws and Doctor of Juridical Science from the Harvard Law School. During his time at Harvard, he was awarded the prestigious Inlag Scholarship and was the recipient of the Joseph Henry Beale Prize for his excellence in conflict in laws. Soon after the completion of his academic pursuits, Justice Chandrachud had a brief stint at the American law firm Sullivan and Cromwell before moving to legal practice at the Bombay High Court. His early years at the bar were marked by an enduring commitment to justice for the marginalized, such as bonded women laborers, linguistic minorities, and HIV-positive workers. In recognition of his erudition, sagacity, and courtroom brilliance, Justice Chandrachud was designated as a senior advocate in June 1998 at the age of 38. The same year, he was appointed the Additional Solicitor General of India, a position he adorned before being elevated as a judge of the Bombay High Court on 29 March 2000 at the age of 40. The dispassionate and even-handed approach of Justice Chandrachud over a period of 13 years at the Bombay High Court led to his appointment as the Chief Justice of the Allahabad High Court on 31st October 2013. During his tenure at the Bombay High Court, Justice Chandrachud also served as the director of the Maharashtra Judicial Academy. Thereafter, Chief Justice Chandrachud was called to serve as a judge of the Honorable Supreme Court of India on 13th May 2016 and was slated to hold the office for a period of 8 years. On 9th November 2022, Justice Chandrachud took oath as the 50th Chief Justice of India, the highest constitutional office in the Indian judiciary. Ultimately, on 10th November 2024, he completed his 24-year-long journey in the justice dispensation system and demitted his office as the Chief Justice of India. Justice Chandrachud's tenure was highlighted by delivery of nearly 612 judgments from the bench, which is a testament of his work ethic, discipline, and prolific decision-making. These include groundbreaking judgments on critical issues involving the electoral bond scheme, Ram Janmabhoomi, right to privacy, decriminalization of homosexuality, Sabrimala temple access, and the revocation of Article 370 from the Indian Constitution, granting special status to the state of Jammu and Kashmir. His powerful dissent in the judgments relating to the Bhima Koregaon incident and the constitutionality of the Aadhaar Act are a brilliant exposition and require a notable mention. Justice Chandrachud has established a reputation as the vanguard of fundamental rights and the rule of law. Justice Chandrachud has been a true proponent of judicial accessibility, inclusivity, transparency, and accountability. His initiatives to digitize the Indian judicial system have left an indelible mark, particularly on the district judiciary. His vision for futuristic courtrooms has transformed the traditional notions of justice delivery. As the Chief Justice of India, he also spearheaded administrative and judicial reforms, such as launching the e-SCR project, implementing neutral citations, and live streaming constitution bench proceedings. Due to his jurisprudential acumen, Justice Chandrachud has been invited to premier institutions, domestic and international, to deliver lectures and discourses with the University of Mumbai, Oklahoma University, Harvard Law School, Yale Law School, Australian National University, and global United Nations forums, to name a few. Sir, we are both elated and humbled to have an eminent jurist, an illustrious scholar, and a legal luminary in our midst to deliver the Vishnupanta Adwanta Memorial Lecture on the present and future of the legal profession, its opportunities, challenges, and pitfalls. We are all eagerly waiting for you to address this august gathering, sir, with bated breath. Please join me in welcoming the Honorable Chief Justice Dr. Dhananjay Chandrachud, an architect of constitutional morality, a guardian of civil liberties, and the true torch-bearer of justice in our times. Thank you.
Without much ado, I now request Chief Guest, former Chief Justice of India, Honorable Dr. Dhananjay Chandrachud, to enlighten us on today's topic, the present and future of legal profession, opportunities, challenges, and pitfalls. My lords.
Thank you. Honorable judges of the High Court of Judicature at Bombay, Principal Shri Rao, President of the Marathwada Legal and General Education Society, Srimati Kalpalata Bharaswatkar Patil, Mr. Shrikant Adwant, members of the faculty, students, and distinguished guests. It is truly an honor to be present today to deliver the Advocate Vishnupant Adwant lecture here in Aurangabad. I spent the formative years of my own career as a judge visiting Aurangabad on numerous occasions. On occasions when I had to sit here as a visiting judge, on occasions when I was invited here for seminars, and I have been invited consistently to Aurangabad by the members of the bar throughout my tenure, something of which I am very deeply grateful and proud. I thank Mr. Adwant for extending this invitation to me to address the gathering. Such events are very significant for young students to widen their horizons, to hear different perspectives and points of view. And I have been preceded by speakers of great repute, learning, and dedication, among them being Dr. Madhav Menon, Justice V.R. Krishna Iyer, Justice Lalit, just to name a few of those who have preceded me. Through this lecture series, I think in some way I reach out to my own father, because this is a tribute to the great tradition in our culture of parenting. And when I say father, I mean fathers and mothers. The theme I have decided to speak on today is the present and future of the legal profession, opportunities, challenges, and pitfalls. The topic is both timely and directly relevant to each of us present here today. India is an ancient country with one of the longest continuing civilizations. We carry the legacy of this civilization and its legal systems to this very day, and we hold it in trust for the future. We have ancient Indian law translated into our personal laws. The system of land recording, revenue collection, and taxation, which India follows today, is based on the recording system developed by Raja Todarmal, one of the 9 jewels in Emperor Akbar's court in the 14th century. I have shared so many fascinating stories and learned such fascinating stories and legends from distinguished former members of the judiciary who hailed from Marathwada, from Aurangabad. Among them, Justice V.S. Deshpande, Justice S.P. Kurdukar. That generation of judges cut their teeth learning Urdu. Land records were then maintained in Urdu. Coming to the present, I've had the most fascinating of journeys with my dear friend Justice Naresh Patil from Aurangabad to Latur, where he regaled me with his own knowledge of Urdu. So we have a very diverse tradition which has enriched our system. We carry fascinating anecdotes into our courts every single day. In the newly enacted Bharatiya Nyaya Samhita of 2023, you will find many offenses punishable with imprisonment of up to 7 years or 14 years. imprisonment in denominations of 7 and 14 are peculiar. They have been borrowed from the Indian Penal Code of 1860. But even if you go back to 1860, it is odd to prescribe punishment in batches of 7 and 14 years for serious crimes. Why was this done? If we dig deeper into the IPC, which prescribed punishment for 7 and 14 years, we find that during the Mughal rule, several serious offenses were punishable by severing of one or both limbs. The Englishmen, when they took over India, found that the severance of the limb to be an outdated punishment. They solved this by replacing the worth of one limb with 7 years in prison. Some English official made this calculation and replaced all punishments of one limb by 7 years and the punishment of 2 limbs with 14 years of imprisonment, or twice the punishment given in place of severing one limb. I'm not sure whether we would adopt the same method while computing compensation for disability under the Motor Vehicles Act. Of course, we don't. According to a recent report published in a website called Live Mint, out of over 1 lakh law graduates entering the job market each year, fewer than 2% get roles in India's top corporate law firms, considered the top rung in the path to success. Less than 2% of 1 lakh law graduate passing every year. While there is some truth to this, in my opinion, the characterization of corporate law as the be-all and end-all to aspire towards is misguided and ultimately perilous. At this stage, let me pose you a question. What is the purpose that the legal professional must aspire to serve? Is it simply to be equipped to meet the demands of the legal market, to navigate and bend the framework of regulation to match clients' needs, leaving aside all ethical considerations? Or is it to be agents of justice, reform, and equity? To be, as Professor Madhav Menon put it, social engineers? The mark of every mature legal system is the recognition that everyone, from the most powerful to the least, from the well-connected to the marginalized, is entitled to certain basic rights, which I borrow from A.V. Dicey's formulation. First, that you should be heard by an impartial or an independent tribunal. Second, where you have a right of representation. Third, a right to confront. Fourth, the right to reason the argument. And fifth, the right to a reasoned dialogue between various stakeholders in the adjudicatory process. Now, let us understand how crucial the role of every element in the legal profession, lawyers, law students, and judges are to each of these 5 critical ingredients. If a legal system were allowed to be relegated only to one of these elements, it would dislodge the ideals that lie at the heart of our Constitution. Issues of lack of access to quality justice strike a blow at the very heart of the notion of the rule of law and the concepts of equality and non-arbitrariness. For this issue is always selective and based on factors that an individual may be kept away for want of socio-economic privilege. One of the speakers preceding me in this lecture series was Professor N.R. Madhav Menon, who said that just as doctors are not identified by their association with illness, but by their healing hands, lawyers too must not excessively rope their identities around fighting disputes on adversarial terms. There is a need for lawyers to reorientate their identities as facilitators of justice before everything. The project of legal education and reform of the legal profession in a diverse demographic environment such as ours is an ongoing experiment. Thus, it is critical that firstly, we facilitate honest and proactive conversations about its promises and drawbacks. Secondly, we must ensure that the conversations in these spaces are not exclusively centered on legal reform in our national law schools, top litigation chambers, and law firms in metro cities alone. It is important that the perspectives and concerns of lawyers from other backgrounds are heard and attended to. Thirdly, we must ensure that the conversation is not dictated by market forces alone. There is a trend towards producing transactional lawyers, and students are actively encouraged and supported by national law schools and private universities to take up careers in corporate law, especially at Tier 1 law firms. As a result of this, at a very young age, students are unintentionally discouraged from taking up careers in public policy or legal aid, areas which are seldom as lucrative but possess a far greater transformative potential. Resultantly, students aspiring to these careers are a minority who do not receive the same degree of support or guidance. Just a few weeks ago, we were tracking the progress of the Indian who went into space, and we were tracking every movement of his. What was he looking at when he looked at the Earth from space? How was he reacting to a weightless environment in the space? I was doing something of the same kind. A very young law student who came to me not from one of the national law schools, but from a very small law school in Karnataka, secured the Fulbright scholarship. And she was on her way yesterday to Harvard Law School. Her parents were not in a position to fund her for that scholarship. Another one of my very young law clerks is now, who's from Kanpur, again a very small city, is on her way to Cambridge on a full scholarship. Another young law clerk who came from ILS Law College is on his way now to pursuing another degree at Cambridge. One of my law clerks has just landed in New York, and she's pursuing her post-graduation at New York University on a very substantial scholarship. A few years ago, one of my law clerks was a young Dalit student, a young Dalit scholar who came into contact with me in Lucknow, went again to Harvard Law School on a full scholarship. Now, these are success stories which have come to my notice. Young students who have mentored, not from fancy law colleges from across the national law school spectrum, but from small law colleges across India. And what I learned from these young students is much more than what I have given them. While a booming economy such as ours needs its share of astute transactional lawyers and corporate bigwigs, we also remain a society marked with deep fissures of inequality, discrimination, and lack of access to justice. A large chunk of our population is subject to laws and whims of those tasked with enforcing them, while lacking the ability to influence them. As lawyers, at least a part of the responsibility to remedy this state of affairs falls on our shoulders. All conversations about the state of the legal profession in our country are incomplete without a reflection of the state of legal education in India today. Lawyers are forged in the fire of the theoretical and practical training they receive as impressionable students of law, and this forms the most abiding influence on a lawyer. I'm a graduate of economics honors from Delhi University, following which I studied at the Faculty of Law, Delhi University. I went abroad for the simple reason that my father told me that I will not enter a law court so long as he is a judge, which meant since he was a judge of the highest court that I couldn't enter a law court anywhere in the country. That's how I went to pursue further studies in law overseas. But when I came back, I drafted my first plaint. And when I presented my first plaint to my senior, that plaint had only written submissions on law, the senior tore up the plaint and said, start afresh. A plaint has to be brief and it must lay the groundwork of facts. You must be aware of the law but not refer to the law in the plaint. I argued my first Order 39 Rule 1 application, having no clue onto how to argue an application for interim injunction before a high court which has original jurisdiction, the Delhi High Court. I was appearing for a client who was supposedly passing off certain essential medical devices as someone else's. And I set out to expound on my propositions of law when the judge said, tell me the facts first. So after all the legal education that I had pursued, I did not know how to draft a plaint. I did not know how to argue an application for interim relief under Order 39. That is truly the state of legal education. It was then, and I dare say, it is even so today in large parts of our country. In many eras, India has seen legal education transform from something restricted to a privileged few to a more inclusive system. The growth of the legal profession in India has witnessed legal education and the legal profession itself ceasing to be the monopoly of a few. In medieval times, the Indian legal system consisted of varied sets of personal laws, and there was no governing uniformity. In the Hindu customary legal tradition, legal principles derived their authority from the Shrutis, the revealed texts, Smritis, remembered traditions, Acharas, customs, and Vyavahara, judicial decisions. Legal education remained confined to the so-called higher castes in society. The advent of British colonialism marked a watershed moment for legal education in India. With the British arrived their common law tradition, and with that arrived the need to train a new kind of legal professional, one who could serve as an intermediary between the British administration and the general population. Law classes were established in the Hindu College at Calcutta in 1797. Government Law College was established in Bombay in 1855, generally recognized as India's British-style law school, along with Madras Law College in or around 1840. While the programs offered by these colleges focused on English statutes, case laws, and legal principles, the pedagogical thrust was on rote memorization and theoretical knowledge, untethered to the socio-economic realities of India. As I mentioned earlier, the advent of lawyers as intermediaries who facilitated legal access also heralded the emergence of a new class of Indian lawyers, educated in British legal traditions, including the father of the nation, Mahatma Gandhi, Dr. Babasaheb Bhimrao Ambedkar, Motilal Nehru, only to name a few. Thus, while the British system sought to produce professionals who could serve the empire, its introduction of the common law doctrine and its attendant concepts such as the rule of law, emphasis on due process, laid the foundation for the cultivation of dissent, critical thought, and ideas of equality and anti-discrimination, values that are not only foundational to our freedom struggle, but also to our constitution. I thought I'll refer to this because it seems like a paradox. Modern legal education, when it was developed in India, was intended to be an intermediary between the colonial masters and the lawyers, or the population was intended to subserve them. But yet, this very system, which was intended to serve the colonial interests, produced a class of lawyers, of freedom fighters. What was it in the system which was intended to subserve the British that it yet cultivated Mahatma Gandhi, Dr. Ambedkar, and a whole host of others? Was it something within their own social system, the Indian social system, which developed these freedom fighters? Or was it something in the very concept of law, in the tradition of the law, the rule of law, dissent that cultivated these freedom fighters? I'll leave that question for you and for posterity to answer. Interestingly, the passage of constitutionalism in India aroused a great deal of interest in several observers from foreign countries. This extended to the systems of legal education prevalent in India for certain policymakers who believed that for the Indian democratic project to emerge as a success, India required well-established rule-based institutions grounded in the concepts of equity, due process, and a right-based order. This led to the investment and organization of substantial sums into facilitating an exchange of ideas between the American and Indian legal education systems, of which persons like Dean Sivasubramaniam of the Delhi Law Faculty were a part. During this time, Indian and foreign observers noted that Indian legal education was in a state of disarray and urgent reform was the need of the hour. They recommended that students be introduced to rigorous scientific, theoretical, and doctrinal training in law. One of those professors was my own mentor at Harvard Law School, Professor Arthur von Mehren, who came from Harvard because he had been tasked with studying legal education reform in India by the Ford Foundation. He was invited by the University of Delhi to be part of the Gajendra Gadkar Committee, which was set up to provide recommendations for improving the quality of legal education at Delhi University and other institutions in the country. This led to the pedagogy at the Campus Law Center, where I learnt my law. I had the privilege of being the beneficiary of this system. We were taught by professors relying upon the case law method or the Socratic method, where we would be given cyclostyle copies of, say, 50 cases per subject. We had a semester system and were taught up to over 30 subjects, in a striking departure from other law schools in the country in those days. This taught us young students how to carry out an independent analysis and think in original terms about legal quandaries, a quality that many traditional curricula lacked till date. The key aspect of the legal education which we received in Delhi University was that we were not taught what the law is, but we were taught to think about the law. We were taught to think about what the law should be, what were the failings of the law. The 1960s, the 1970s, and the 1980s saw greater interest in these areas, spurring the growth of a young generation of Indian academics and thinkers. Among them was Dr. Madhav Menon. While being at the Delhi University as a faculty member, he came into contact with several American law professors working for the Ford Foundation. Professor Menon possessed a deep commitment to the egalitarian principles at the heart of the Indian Constitution and believed that for the furtherance of the Indian legal project, legal education needed to serve the needs of all society. Noting that programs available in several institutions were far removed from any real concern of the socio-economic and cultural problems affecting society. That is how we founded the first legal aid clinic and led him to collaborate on a national report on the issue of access to justice in India at the invitation of Justice Krishna Iyer. A few years down the line, Professor Menon introduced the idea of the 5-year law program, where students would enter directly from high school and matriculate courses into a comprehensive BA LLB 5-year system. Thus far, it has been a resounding success and yielded some very interesting projects. Apart from producing several Rhodes Scholars, top corporate lawyers, and judges and senior advocates, NLS alumni have founded initiatives like the Alternative Law Forum, the Vidhi Center for Legal Policy, and the IDEA Initiative, which was founded by Professor Shamnath Bashir, namely increasing diversity by increasing access. I would like to pause for a moment here to reflect on the importance of such a system of legal education. Our students, those studying in state universities, are seldom taught to question the legal systems that engulf them, to examine what the law could be rather than what the law is. A system that fails to produce independent thinking lawyers who can spur reform becomes a legal system entrenched in its own prejudices and fault lines. In the mosaic of Indian legal education, institutions across India, while public universities, such as the government law colleges, the Faculty of Law of Delhi University, Aligarh Muslim University, Banaras Hindu University, may not provide cutting-edge curricula. They are sponsored by grants received from the governments and more affordable to the average Indian. Principal Rao just referred to the fact that our fees here today are fees which are capable of being met by ordinary students. One of those who received the gold medal here comes from an agricultural family, like indeed that student of mine who has just landed in Boston this morning to pursue her LLM at Harvard Law School. But these are all products of state universities, aided universities. Many students who may have otherwise had to forego a chance at a legal education have been able to access it solely on account of the presence of such institutions. Therefore, it is important that we do not ignore or sideline the role that these institutions have played in the larger project of the law. Several legal luminaries have come from these institutions, especially from my generation, and it is important that students from these universities do not feel left out or disadvantaged in comparison with their peers from national law schools or private universities. The public funding that these universities receive can be directed to ensuring that students get access to world-class databases and up-to-date libraries, as well as computer resources. What these educational institutions perhaps lack in terms of the qualifications of the faculty they possess can be made up for by organizing guest lectures. Apart from this, students must be encouraged to undertake legal research, which will enable them to widen their horizons and approach the law from informed, theoretical, and critical perspectives. We had a maid working with us until last month. If you asked her to open the newspaper and give you a newspaper of a particular date, she would not be able to do so, though she always said that she has passed her 12th standard. She gave me varying explanations. When she joined our service, she said I had passed standard 12. Later on, she says I have passed standard 10. Later on, she said I have failed standard 9. So a good cross-examiner would have been able to deduce the inconsistencies in the answers. But the reason I mention this is because her daughter was a revelation. Her daughter went to an English medium school. Her mother washed pots and pans in our house. But her daughter went to an English medium school. When I went every morning, on my morning walk, I would see her all dressed in her white pinafore dress going to her school. I always waited for her near the bus stop and spoke to her on what she was studying. She spoke impeccable English. She spoke better English than possibly some lawyers and many judges. I thought that we must give her an opportunity at success. So my wife and I decided to sponsor her education, and she is now doing the 3-year BA law course at the Jindal Global Law University. So what you find across India is that given the opportunity, we have young people across the board who have the talent, they have the ability. They may not speak English at home, but they have the ability, the promise, the innovation to learn the language so as to speak the language of the law. Coming now to opportunities available to young lawyers around this time, in the space of examining reform in legal education, a recurring observation that has popped up was that the Indian legal landscape, prior to the economic reforms of 1991, suffered from a crisis of equitable, well-paying opportunities for young law graduates. To recount an incident from my days as a law student, over a cup of tea between classes, we could bunk some classes because we did not have the biometric system of attendance. I generally did not bunk classes. A classmate of mine approached me and asked, "How do you plan to sustain yourself and earn an income for yourself?" He asked me in Hindi. He used to come from a small village in Haryana. And he asked me in Hindi, "How will you sustain yourself as a lawyer?" I was a little nonplussed at his question and said, "Through the practice of law." In response, my classmate took a very serious note and advised me. He said, "I recommend that you sign up for an oil or a petroleum or a gas dealership permit. This will allow you to earn an income sufficient to sustain yourself while you practice the law." Mind you, those were the days of the license Raj, and litigation was the monopoly of a select few people, apart from being notoriously tough for an outsider to Delhi to break into. Justice Manish Pitare broke into it and did brilliantly well in Delhi, which is just an indicator that the marketplace ultimately rewards merit. And whatever the barriers to entry may be, if you are good, you are bound to succeed. With the introduction of liberalized economic reforms came the need for corporate attorneys who would be deftly able to navigate the increasingly complex legal and regulatory frameworks on behalf of the smallest of entities, ranging from one-person companies to multinational corporations with a multi-jurisdictional presence. New areas of the law, which were previously unheard of, opened up, ranging from digital competition law to trade law and technology, media, and telecommunications laws. Practitioners of these areas have gained recognition at par with their global contemporaries. After my retirement, I am now in the private space. I teach law, but I also in the private consultancy space. I am really impressed by the innovation which our youngsters have brought to law. The other day, I was asked for an opinion by someone who was specialized in space law. I'm asked for opinions by people who have been specialized in sports law, in media law, in entertainment law. So these new opportunities have been picked up as India has changed from a tightly controlled economy into a broad-based, diverse regulatory landscape. While careers in corporate law have become much more lucrative, many find the prospect of taking up a career in litigation discouraging. Largely, women have turned away from the legal profession and have taken to careers in corporate law because they believe that careers in corporate law are more feasible for women, especially as they progress in the whole spectrum of familial responsibilities. This has partly got to do with the fact that employers, often senior advocates or advocates with well-established practices, do not pay their juniors adequately. This needs to undergo a change if we want to retain the best talent. In the Supreme Court of India, we used to recruit and we still recruit law clerks. Every judge is entitled to 5 law clerks. I found when I joined the Supreme Court that law clerks were picked up on the telephone. Network of friends at the bar, networks of friends on the bench calling up judges and saying, "Please take so-and-so as your law clerk." I felt that this system has to at least partially change, if not completely change. So during COVID times, I prepared a white paper on democratizing access to the Supreme Court by allowing for law clerks from unconnected legal backgrounds, first-generation lawyers. It didn't see the light of the day for 3 years, but when I became Chief Justice of India, I revived my white paper. We have been holding the examination for recruitment of law clerks, if I am correct in my memory, at 23 different locations in India, even in island locations. We then hold a process of interview. We allow the young law students to match their preferences for judges. We allow them to give their preferences of who they would like to clerk with. Just as young students can say, I want to, or medical students can say, my first preference is this college or this discipline. I said, let's climb down from that pedestal and allow these youngsters their preferences. We cannot assure that their preferences will be necessarily adhered to. But the net result has been, we increase the amount payable to the young law clerks. Now I believe that they are paid 80,000 rupees for the first year and 90,000 for the second year. How many lawyers pay a young law student who has just passed law 80,000 rupees for the first year? But my logic was very simple. My logic was that if a young student comes from, say, Madurai or Tiruvananthapuram or Samastipur or Gadchiroli or Ratnagiri, I mentioned Ratnagiri because one of my most dedicated law clerks is from Ratnagiri. How do they afford the cost of living in Delhi, commuting to Delhi? Many of them are young women lawyers. In the winter particularly, after work got over at 10:30 or 11 in the night, most of these law clerks had to take Ubers and go home. That cost money. So if we want to genuinely encourage young talent from across India, we as lawyers, we as judges need to make that first step. I understand that it would be difficult for a young lawyer, say, pursuing the first year from Aurangabad to get the kind of salary which we in the Supreme Court pay. We pay it because we are funded by the government of India. I pay more now that I have started recruiting young lawyers to my office. I know that they would be willing to pay and work for much less. I know that there would be young lawyers who would be willing to work with me because I bring my experience of 25 years. But I still feel that we have to give back to society. Many of my colleagues would ask me, aren't you paying too much to these young lawyers? Very legitimate question. I'm not at all disparaging that question. And I would say that, brother or sister, as the case may be, when you work with these young law students and young lawyers, you will realize that they are not just here to learn, but they teach you as much as they learn. The process is about us seniors learning from the young. Don't we learn from the young within our families? I'm sure when all of you as parents sit with your children, you learn so much from them just as much as you share with them. I have learned so much from a young Dalit student who told me about this real stories of marginalization, of the discrimination which is still practiced in villages across India. I learned so much from young women lawyers who would tell me how difficult it is for a woman to get a job today in a lawyer's chamber. I learned so much as a professional from students who came across India in the quest for learning the law from us, judges and lawyers. So our attitude towards young and young lawyers needs to undergo a change if we want to retain the best talent. In today's times, while this generation has more opportunities than we ever did, it comes with its own pitfalls. Law graduates today are entering an increasingly complex, competitive, and fraught market. To navigate this, lawyers firstly require mentorship that can guide them to understand their own aptitude. Mentorship not merely by seniors, but mentorship by peers. As judges, we have been mentored by our own peers. People we sit with in the judges' lounge every morning have mentored us. Likewise, mentorship in the law colleges takes place by friends, by peers. Secondly, I would advise lawyers to build focus and discipline and work hard for whatever it is that they wish to pursue, to cut through the noise surrounding them, be it in the form of overachieving colleagues, criticism, and self-doubt. You will always find that there are colleagues who overachieve, brilliant colleagues. But this universe is not only meant for brilliant achievers, it is meant for the average individual. So be it in the form of self-doubt, criticism, learn to face it. There are no shortcuts to success and there is no substitute for hard work. Let me next deal with the need for reform and innovation. We must not commit the folly of assuming that the traditional modern model of lawyering will remain intact. The vitality of any legal system, foremost, depends on the ability of itself and its participants to adapt or risk being left behind. This century has ushered in an era of unprecedented large-scale change driven by technological advancements and globalization. In order to adapt, it is necessary to adopt a futuristic outlook. While careers in corporate law have become much more lucrative, many find the prospect of taking up a career in litigation discouraging. In today's times, while this generation has more opportunities than we ever did, there are yet absolute pitfalls. Lawyers from traditional law schools have a crucial role to play in the craft of lawyering and the delivery of justice. The courts of our district judiciary are overwhelmingly represented by lawyers from traditional law schools. Students from these law schools are more likely to practice and give back to the communities where they come from. The quality of our local bar and indeed of justice is contingent on how well we can perform at these law schools. One of the most significant barriers we face today is what I call opportunity dissonance. Law students face myriad barriers to avail quality opportunities to improve and upskill. Law schools are only recently realizing the value of imparting practical skills, which students can use in their legal practice. Besides theoretical learning, the craft of law includes the power of persuasion, the ability to articulate your thoughts, and the knack of linking together the most relevant arguments and legal propositions on your feet. The opportunity barriers at law schools further translate to internships. Many students face a lack of direction in seeking quality internships where they can make up for a lack of practical training in college. Fortunately, there is a bench of the Bombay High Court at Aurangabad. Students in many law colleges have to travel to faraway cities on their own expense to seek mentorship from quality lawyers. The opportunity cost barrier has a generational effect on the quality of the bar as well as the quality of justice delivery. Despite these barriers, our aim must be to constantly strive to make a critical thinking body of students who learn to challenge injustice. Sometimes you will think about what the point of questioning injustice is. How does it matter if one lawyer raises questions about a problematic law, a faulty prosecution, or for the rights of a laborer? You will feel dejected and think that your efforts are futile. The power of one person acting alone may overwhelm your imagination and make you think that all is pointless. But there is no lack of examples about what one person can achieve. One man set out on a march from Sabarmati to Dandi to oppose the salt tax. One man led the Mahad Satyagraha to drink the water of Saudar Lake and reclaim the dignity of marginalized castes which were being denied drinking water. One woman refused to go to her husband from child marriage and set into motion the law against child marriages in India. Whenever a single person stands up of principle and acts in defiance to defend his or her ethic, she creates a tiny ripple of hope. A small pebble in the water can change the pattern on seas and oceans. When several tiny ripples act in different ways towards different directions, they have the power to create cataclysmic change. These changes are not small, they are not pointless. They mark the boundaries of human imagination for an egalitarian society. Each and every injustice exposes the limits of our humanity. It is an example of the failure of our elaborate systems and endless equivocations. But when you stand to defend the defenseless, when you challenge the status quo and question injustice, you create a new path of possibility. The flip side of this is dark. If law students from your college and from colleges like this are not motivated by social passion, if your call is not to answer the test of ethics and justice, if constitutional values become secondary to communitarian considerations, then it will create a microcosm where justice and ethics are secondary to the greed of human nature. Just like you have the power to change the world, you also have the power to keep it stationary and resistant to change. You have the power to create a system which burdens the weak and privileges the powerful. When no one stands for justice, justice returns its favor by protecting no one. As I said, when no one stands for justice, justice will return its favor by protecting no one. This is the pitfall of our legal profession. We are surrounded by egalitarian values of the Constitution. Our vocabulary has evolved to talk about the great promise of equal citizenship and the grand project of democracy. But all this will be meaningless unless we can create constant defenders and champions of our value system. What is the primary passion of a law student, if not the call of service to contribute to something bigger than oneself? You may take many paths in life. Besides litigation, some of you may join a law firm. You may be an in-house counsel or a consultant, or you leave the legal profession altogether. The other day, I met a young lawyer who has turned a graphic designer. But your sense of service, passion for justice, and commitment to values must not leave you in your professional life. The legal profession must go beyond traditional doctrines or rote skills training, emphasizing the broadening of lawyers and related professional capabilities in analytical thinking, ethical judgment, communication, multidisciplinary knowledge like technology, environment, and human rights, and social sensitivity. Despite producing some of the finest legal minds, our legal education system continues to grapple with fundamental gaps that hinder its ability to meet the demands of the 21st century. We are witnessing today a digital explosion. Data protection disputes, climate change litigation, online dispute resolution, and digital-first regulatory frameworks are becoming the new norms. Pragmatically, this means reforming legal education and continuing professional development programs to foster cross-sectoral expertise. By cross-sectoral expertise, I mean digital law, data privacy, environmental law, cultivating critical reasoning and social empathy, and encouraging collaboration with other professions such as technology experts and social scientists. To achieve this vision, law schools and continuing education programs must anticipate the evolving landscape of legal careers and actively prepare both students and current professionals to succeed within it. Our curricula must expand beyond traditional doctrines and procedures to include foundational training in data science, user experience design for legal technologies, and principles of algorithmic accountability. Students need to develop skills to assess AI model outputs, detect biases in training data, and work collaboratively with software engineers to refine tools that uphold constitutional values and human rights standards. Moot court exercises could incorporate artificial intelligence adversaries that challenge students to predict algorithmic decisions and formulate compelling arguments to hold automated systems accountable. During my tenure as Chief Justice, I had the great opportunity of unveiling several technological reforms that I am happy to report have remedied to a great extent the issues that plague our judiciary. We introduced e-filing of cases, available across nearly all states. Further today, the Supreme Court judges operate virtually in a paperless manner, and they are provided with scanned, bookmarked, and digitally signed case records, which they access, read, annotate, and preserve for their reference. It may be a separate matter that these digitized files are used more by the lawyers and the law students who assist judges than the judges themselves. That's a generational issue. As today's judges retire in the future, and a younger lot of judges will come into the Supreme Court, this will change, but the trend has to continue for the future. Our MOU with the IIT Madras has proven to be a resounding success, And a team of generating AI researchers have built a model that can automatically extract parameters from petitions, documents, and files and give a recommended compensation figure in motor accidents cases. The Supreme Court now relies on AI to provide real-time transcriptions of live arguments of cases. We have used artificial intelligence to translate Supreme Court judgments of every language recognized by the Constitution. We have used artificial intelligence-aided software for the purpose of putting out our judgments free of charge across India in the eSCR platform. In the last part of my presentation, I want to briefly deal with gender equality in the legal profession because there are so many young women lawyers here. Over the last decade or so, gender diversity in the legal profession has become a matter of great interest. But the challenge of representation and the gender gap remain underexplored. In 2023, responding to a query in Parliament, the then Law Minister laid out some statistics regarding the percentage of women on the roll of bar councils across the states. According to his statement, women comprised of only 15.31% of the total advocates enrolled as per the data provided by the Bar Council of India. Historically, several women like Regina Guha or Cornelia Sorabji or Sudhanshu Bala Hazara had to wage long drawn-out battles to ensure women pleaders receive equitable treatment from courts. Cut to today, while we see that women are entering the profession in large numbers, gender disparity remains starkly relevant. Yet times are changing. In many states today, over 70% of the new recruits to the district judiciary at the lowest levels are women. Last year, in the Supreme Court, in 2 lots, we designated 12 and 11 women lawyers as senior advocates, 23 senior advocates in 1 year. This was in comparison from 1950 to 2024, when we had all of 12 women designated as senior advocates. I was asked, will these women succeed at the bar? My point is different. My point is we have created an equal opportunity. I can't compel a client to brief a particular lawyer, but creating an equal opportunity for lawyers allows them to demonstrate through their hard work that they have the ability to succeed. And I'm glad to note that so many young women lawyers are now succeeding at the top of the legal profession across India. If we truly want to facilitate the entry of women in the profession in greater numbers, the onus is on senior members of the bar and those in apex positions to ensure that many structural entry barriers are addressed. Yesterday, a very young woman lawyer from the Punjab and Haryana High Court came to me. She said, I was trying to gain an appointment with you when you were the Chief Justice of India unsuccessfully, but I have painted an oil painting of you and your father together in a photograph which I found. So I said, how many years have you put in? And she said, I've put in 9 years at the bar. And said, how many lawyers do you have who have become judges of the Punjab and Haryana High Court? And she said, I think about 12. I said, wait a minute. So we went to the website and found that 13 women have been appointed as judges of the Punjab and Haryana High Court. And 5 more, I believe, are now in the pipeline to become appointed as judges. Women lawyers often report that they face a great deal of casual sexism, both inside and outside the court. One incident narrated by my inspiration, Justice Ruth Bader Ginsburg of the US Supreme Court, came to my mind. While arguing a gender discrimination case before the court, Justice Ginsburg, then Justice Ruth Ginsburg, a judge commented to her that women had even been receiving equal opportunities in the army, to which Justice Ginsburg pointed out that we have yet to be allowed to step into flight training. This invoked a sarcastic remark from the judge, one of whom remarked, "Oh my dear, don't tell me women aren't in flight. The women in my life have been in the air for years," the judge of the Supreme Court said. In response, Justice Ginsburg said, "Indeed, Your Honor, and many of the men I know don't have their feet planted on the ground." Over the years, I've had many women work with me as my law clerks who I have found perform at par with their male counterparts. Data from several law colleges also suggests that while women tend to outperform their male classmates academically, yet when it comes to sustaining a career, many are forced to drop out due to the pressures of marriages and motherhood. When I attended the convocation of the Postgraduate Institute at Chandigarh, one of the leading PG institutes in the country, I was very impressed with the fact that at the convocation, women were not, especially in the post-graduation, the PG women who were receiving their degrees and medals and gold medals, they were not in pediatrics, they were not in dermatology, they were not in gynecology and obstetrics, which were traditionally meant for women, or reserved, so to speak, for women. These women were from neurology, they were from cardiac surgery, they were from cutting-edge knowledge fields in medicine. So that change is taking place across India. When will that change take place in the legal profession? The choice is for all of you, because each of us will lead by example. I end then with a dicta for lawyers, which Mr. Fali Nariman, the great doyen and mentor for so many of us, gave. Mr. Nariman, in his candid yet authoritative autobiography, summarized some pieces of advice for lawyers. I encourage all lawyers to pick up this book and read it at least once in their lifetime. Fali Nariman's pearls of wisdom are all the more relevant for today's generation of lawyers. So I will be paraphrasing these for you all today. First, he says, always be honest and responsible with your opinions. Avoid the sporting chap syndrome. Law is not a game. Second, know your law and facts deeply. Be careful not to get lost in trying to fit your case into old judgments. Don't suffer from case law diarrhea. And if your opponent throws insults, ignore them. Responding won't win you the case. I've carried Fali Nariman's principle: if your opponent throws insults, ignore them. I'm carrying that into my retirement as well. To people who throw insults at me, I have only one answer. If that makes you happy, so be it. Happy in insulting others. Third, be clear and precise in court. Prepare well, think like a lawyer, and answer the judge's questions promptly. Give your answer first, then your point. It's gold. Fourth, stay up to date with all important judgments. Use your downtime wisely. Read, observe, learn how to argue and how not to argue. Fifth, when you have multiple arguments, lead with your weakest, but make it your strongest effort. Save the best argument for last and let the court guide you to it. That's a masterclass lesson from Wilfred Green, who was the pioneer of the Widnesbury principle. Sixth, know your authorities thoroughly, even anticipating adverse points. Seventh, beware of Parkinson's law. Harder work attracts more work. I have found this to be especially true as a judge. The hardest working judges do the most amount of work and tend to work the most. Stay busy, stay sharp, and avoid complacency, especially if you are on a fixed salary, no matter which field of law you find yourself thrown into. Eighth, always cite relevant cases fairly. Never mislead by citing overruled decisions. Integrity is everything. Ninth, it is better to understate your case rather than overstate it. Never claim a cast iron case. Judges appreciate humility and openness. Don't count your chickens before they hatch. Luck and unpredictable events affect outcomes, so stay grounded. Don't be funny or overly rhetorical, especially early in your career. Jokes belong elsewhere. Avoid absurd arguments, aiming just to be clever. Sometimes the best move is knowing when not to play that note. Leave anger outside the court. Even in heated arguments, calmness wins more than passion. Remember Lord Eldon's wisdom. You can be very angry and very wrong. Cultivate camaraderie at the bar. Don't be nasty or quarrelsome. Your colleagues shape your reputation and support. Always address the court properly. Courtesy matters more than you think. Finally, never knowingly make false statements. If you disagree with a judge's decision, discuss it respectfully out of court or appeal. Never raise personal attacks on judges or your opponents. Make your arguments crisp. Judges seek relevance, not verbosity. Focus on skill and substance over showmanship. The jury system may be gone, but precision in argument remains essential. Remember, advocacy is a human art. Control your temper. It's half the battle won. Let me add a tip of my own here. Lawyering is an incredibly stressful profession, and several studies have pointed out that lawyers' jobs can be often very stressful, making lawyers more prone to addiction and struggling with mental health issues, such as depression, at higher rates than the general population. One of the great sadnesses which I had, both as a lawyer and as a judge, was to see an extraordinarily talented colleague at the bar just fading out, becoming a victim to alcoholism, becoming a victim of drugs. And you said, what happened to this person? A brilliant young lawyer. Was it the stress of the legal profession? That's something which we need to understand, talk to each other, understand people who are in distress, why they are in distress. One worrying trend I have observed is also the increase in the number of suicides in our law schools. These are concerns the legal fraternity needs to systematically address. Chambers, law firms, and all other organizations employing lawyers must ensure that they make provisions for access to quality mental health care, just as we have insurance for accessing physical health care. I think all our courts, and the high courts must start with it, must have a dedicated professional who must come for mental health advice to young lawyers. These are not just tips, but the essence of good lawyering, a blend of integrity, preparation, humility, and respect. Keep these close as you navigate your legal path. So what must we all do? What must we all do? Embrace learning, lifelong and continuous learning, in spirit and action. Seek mentorship, but think independently. Value ethics. Without it, the most brilliant mind is of little use. Cultivate empathy for the marginalized, for justice cannot be served in isolation. To conclude, let me borrow from the philosopher Horace's dictum, dare to know. The present holds many challenges, but the future of the legal profession is full of promise if you, the next generation, are willing to question, to learn, to serve, and to lead. I'm very grateful for this opportunity. Namaskar.
Thank you for your Lordship.